Are you ready to make the most of your oil and gas mineral rights? Welcome to the Mineral Rights Podcast. Get the knowledge and resources you need to manage your minerals and royalties. Here is your host, Matt Sands.
Hello and welcome to the Mineral Rights Podcast. I'm your host, Matt Sands, and I'm joined by my co-host, Justin Williams, and we're here to help you make the most of your minerals and royalties. In this episode, we're going to do a deep dive on the different types of rights associated with the mineral estate. So, you may think, well, I have mineral rights. That means I can, get royalties, right? Well, there's actually a lot more that goes into it. And there are a lot of other property rights that go with owning surface land. And so we're going to break this down because this is a really important concept to understand, because I've had several clients, Justin, that I've, had a conversation with them. They say, hey, we've inherited these mineral rights from our mother, father, we need an appraisal. Can you help us? And digging into it, it's like, well, you actually don't own the minerals. Some of these are minerals. Some of them are actually non-participating royalty interests. Some of them are overriding royalties. And, that they don't understand that concept of, the nuances between those different rights, because they are very distinct and separate. And we'll talk about how they all fit together, because this is really a foundational concept when it comes to owning mineral rights, just because it dictates your rights, right? What you have and what you don't have, and what you can and can't do. And so this is, I think, maybe long overdue, but it's a good topic.
I think so, Matt. It's a great topic for people. It's really a foundational topic, and it's one of those that we encounter this more than we realize just in living our life. But at times we get into it deeper, or maybe different aspects matter that we haven't gotten into before with mineral rights. And Matt, for the average mineral owner, they've had a career doing something else. This is not a concept that they were taught in school or something that was introduced to them. And even for trained legal experts, if they haven't worked in the mineral world, this can be a concept they don't realize applies to mineral rights. Yeah,
that's a really good point. And I think that, certainly if you're in the real estate profession or legal profession, you're doing property law, then obviously you know all this. But beyond that, this was a concept that I had to learn. When I first got into minerals, I was very knowledgeable in terms of oil and gas operations and, all of the technical stuff. But then when it comes to the land and property stuff, unless you're a landman, or somebody that deals with these types of things, it's a new concept. And so, but it's not difficult. So we're going to talk about that. And, one of the analogies that's used a lot of times by attorneys and others is this concept of the bundle of sticks. And so this is something to really understand. These different rights that come with the minerals is its set of separate and distinct rights that in totality comprise the mineral estate. And so when we talk about that, we'll talk about exactly what those rights are. But before we get to that, I think it really helps to understand the different types of property ownership, because that will dictate obviously what you own or what you don't own. And I think it's really good to start at the beginning there, but there's three main buckets of land. Justin, do you want to talk about those and talk about the nuances with each?
The place to start here is the full bundle of sticks. So you own the bundle and all the sticks in it, and that would be considered fee simple. You own the surface, you own the minerals. This is common for property that has never been severed, or the mineral rights haven't been severed from the land. For example, land that has been in a family's possession since a government patented that land, or the government issued the patent to the land. Because you receive that as fee simple. You own all the sticks in the bundle. There's surface only rights, so you own and control the surface, the dirt, the structures, the crops, but someone else owns the minerals underneath the ground. This is increasingly common if you bought land in an oil producing state without specifically confirming you were getting the minerals. There's a real chance that you don't own the minerals and that those were severed previous to you purchasing the surface rights. Then there's the severed mineral rights. You own the minerals beneath the track, but not the surface above. This is where most of our listeners live. You may have never have seen the land where the mineral rights are actually owned, or someone else may be farming it or building on it. But underneath it, those oil and gas rights belong to you if you own those severed mineral rights. And Matt, something that we talk about a lot, to put in context here, is the dominant estate concept. And it's really critical, especially for mineral owners. In virtually every state, the mineral estate is considered to be the dominant estate, meaning the mineral owner or an operator holding the lease has the legal right to use the surface in a reasonable way to access and develop what's below. Right? If you only own the severed mineral rights, somebody else owns the surface, they allow you no access to get enjoyment out of your property. that would create an issue. And so the mineral owner has the dominance there to be able to reasonably develop, even without the surface owner's permission. The surface owner cannot block development. However, Matt, this can get into a really complicated thing. And this is why we typically use leases to set boundaries before things start so that we don't get into constant litigation about what it can and can't happen.
Yeah, that's a great point. And obviously, they're not going to just come in and occupy the land and drill a well without your permission. And so that would be in the form of a surface use agreement. So if you own the surface rights and they want to put a well pad on your property, they would approach you and say, "Hey, are you agreeable to us taking, 5-10 acres and creating a well pad and, leasing this land from you basically?" And that's through a surface use agreement. And there's all sorts of compensation for surface damages and, certain terms in that whole thing. And you can refer to the episode that we did on surface use agreements to find out more about that. But I think that, what you mentioned, Justin, is really important, that when we have mineral rights that we've inherited in particular, the concept of owning those minerals is very distinct and different from surface rights. Because obviously, if you own the surface, it's a tangible thing that you are using, that you can enjoy. And you don't have multiple people that just show up and say, "Well, this is also my surface rights," right? Usually it's, owned by you, and then maybe you have joint tenants. So you might have it with, if you inherited a piece of surface land from your parents or something, maybe you and your brothers and sisters own that tract of land, and you all collectively can decide what you want to do with it. But with minerals, there's this concept of ownership that is distinct and separate. And you can do, and these bundle of sticks apply to your ownership individually. So you have an undivided interest. And so that means that you're not sharing it with other people. That fraction of those minerals that you own, you can do what you want with it, obviously within the constraints of the law and within the constraints of the rights that you enjoy, in terms of the bundle of sticks. And so I think that's really important to understand, because oftentimes I get questions from clients and from listeners about, "Well, I have this oil and gas lease, and my cousin got one too, but they don't want to lease, and so I'm kind of in this conundrum." Well, you don't have to, depending, again, 99.9% of the time, obviously you need to look at the specifics of your situation, but 99% of the time you have an undivided interest, and you can do with that what you want. So if you decide that you want to lease it, or if you want to sell it, you can do that. And if your cousin wants to do the opposite, well, that's their prerogative, and they can do just that. And there's no conflict between your separate ownership, which is actually pretty nice when it comes to minerals, because as these interests have gotten subdivided over the generations, now it's not uncommon for you to have a very small fraction. And if you had to deal with 100 other people to try to agree on a lease, it would probably never happen. So, that's an important concept as well.
Absolutely, man. It is a very important concept. And if we back up to fee simple, so you think about owning all the sticks in the bundle's still tied together and hasn't been separated. Now we're going to get into talking about mineral rights and what are the specific rights related to mineral owners. So we've untangled the bundle, we've separated out the surface rights, and now we're just focusing on this multiple sticks left in the mineral ownership, Matt. And I think that's a concept that people get a bit confused on, because they don't understand that if it's already been severed, how do I still have multiple rights left? But you can think about it as surface being more than one stick in the bundle, minerals being more than one stick in the bundle, and you've separated those independent piles of sticks. And Matt, the first one would be the right to develop. And this is often, Matt, when we're working with an oil and gas company, this is what the operator's interested in, to go actually produce on that land.
So I think that's an important concept, because, when we talk about the surface rights, like Justin mentioned, the mineral rights are just one of the bundle of sticks within overall property rights. Again, that fee simple. And just a very high level, quick overview, you could have, timber rights, you have the right to build a home, you have access rights, the right to sell associated with that fee simple, and then you also have the mineral rights. And then when you take that bundle of sticks, within the big overall bundle of sticks, there are 5 distinct rights that are associated with the mineral estate. That's the right to develop, or in other words, right to drill well, in this case, the right to lease, the right to receive bonus payments, the right to receive delay rentals, and the right to receive royalty payments. And so, interestingly, you can separate out those rights and you can convey, only the royalty, for example, and that's where the non-participating royalty interest comes in. And we'll describe what that means. But this is really sort of an interesting concept that, exists with the mineral estate. So let's go through each one of those. So Justin, you want to talk about the right to drill first?
The right to drill. So it's a foundational right, the ability to actually go in, drill those wells, and produce oil and gas and other minerals from the land yourself. In practice, very few individual mineral owners ever exercise this right directly. Requires capital, equipment, expense that most people don't have. And instead, mineral owners typically transfer this right in an oil and gas company through a lease. And then if the mineral owner decides to develop the estate himself, this right allows him to explore, drill, produce, transport, store, and market the minerals. So Matt, this is when we're talking about signing a lease with the operator, this is really the right that we're transferring to them in exchange. And this is predicated on already having the executive right that goes into the next one here. So the executive right, probably the most powerful or arguably the most powerful, is the right to negotiate and sign that oil and gas lease. The right to lease is commonly called that executive right. And the executive right is the stick that gives you the negotiating power. The person who holds that executive right is the one who sits across the table from the oil company, negotiates the royalty, lease terms, the bonus, and the duration of the lease. And Matt, what can get tricky, and I actually have a non-participating royalty interest, is that somebody else can own this executive right of being able to sign the lease, and you have a royalty directly tied to the decisions that they're making. It's really not uncommon in the oil and gas world.
Yeah, and actually I own the other 4 sticks in the bundle on a mineral tract in East Texas. And the seller retained the executive rights, which is not the best situation. I'd say it's probably the least ideal situation. And obviously that those minerals aren't worth as much as if you had the ability to negotiate your own lease. You're at the mercy of someone else, and they may or may not be working in your best interest, right? So usually these are maintained together. So when you sell the minerals, you're selling all 5 of these rights. But it is interesting that you have that executive right that can be separated out and maintained. And that's just a possibility, but I would say not ideal. And I would say that within the concept of the right to drill and the executive right, when we talk about conveying or signing an oil and gas lease, what we're doing is we're actually conveying the right to drill to that lessee. And so that means that it's actually a conveyance document. You're conveying that one stick in the bundle of sticks. So it's sort of like a deed of that right for a limited period of time. When we talk about term royalty deeds, that's another concept where you can convey the royalty for a certain period of time or maybe a certain amount of money until that's paid back, then the royalty will revert back to you. So these can be used very creatively, and I will say that I've seen a lot of very creative deals in oil and gas, and so that's all really starts with these 5 sticks. So the third stick, which I think is probably one of the most favorite sticks of most mineral owners, is the right to receive a bonus payment when you lease the minerals. And this bonus payment, in the past, it used to be paid on an annual, this delay rental or annual payment. The check would get written every year to hold the lease. Well, this bonus payment is an upfront payment. And so when you have a lease, it's typically an upfront, a paid up lease, which means that the bonus payment is paid upfront in one lump sum to hold the lease for the full primary term. So if it's a 3-year lease, they'll pay you, $500 an acre or whatever the lease bonus is per net mineral acre. And that will hold that lease for that full primary term. And then if they drill a well, the lease will go into the secondary term, and then it'll be held by production as long as there's production in paying quantities. So this key nuance here is the right to receive the bonus is distinct and separate from the right to receive royalties. And again, like we said before, it's possible to own one without the other. And like Justin mentioned, that non-participating royalty interest is exactly what happened is if you only conveyed a portion of the royalties, for example, then that would generate and create a non-participating royalty interest. The non-participating part means that you do not have the right. You're not participating in the leasing process, basically. So we have some discussion about taxes as well that we've mentioned. And when you have a lease bonus payment, it's worth mentioning that is typically just taxed as ordinary income. So unlike if you sold the minerals, that would be subject to capital gains and the potential tax benefits and lower tax rates that you get with that if it's long-term versus a short-term investment. And this in this case is just, mixed in with the rest of your income, and it's taxed at ordinary income when you lease the minerals. So that's important to know as well. Justin, you want to talk about this concept, which really isn't applied too much today, but it is still part of the bundle of sticks. What's the number 4?
Yeah, number 4 is the right to receive delayed rental payments. And like you mentioned, Matt, this is not near as common as it used to be. Nowadays, the oil and gas operators and modern leases are structured as paid up leases. And you hear that quite often, meaning the entire delay rental for the primary term is rolled into the upfront bonus payment that typically covers the primary term. And then, as Matt mentioned, if they drill a well, it's held by production. So this is less common, but it is distinct in its own way. So think of it in this context. The oil company leases your minerals for a set term. If they haven't started drilling yet and they want to keep the lease alive rather than losing it, they can make these periodic delay rental payments, which is a check to the owner, basically saying that we're holding this lease with this delay rental because we do plan to come back and develop this. And again, many leases, if a well is drilled and there's production, then this delay rental really is a non-issue. And we don't see this as much, Matt, but it is a fundamental thing that you see in doing title work, where the delay rental payments are specifically included or excluded in older deeds.
Yeah, that's it's an interesting concept, but again, not something you'll deal with a whole lot usually. And then the last one is, I would argue, the most important stick or the most important right when it comes to the mineral estate, and that's the right to receive royalty payments. And this is where the majority of the value of your minerals resides. And when somebody's making you an offer to purchase your minerals, it's directly proportional to the royalty rate that you've negotiated. So let me mention this, time and time again, and I do that because it's just such an important concept that when you have an opportunity to sign a new oil and gas lease, in my opinion, again, this is not legal advice, but I always try to get the highest royalty payment, even if it means a much lower or even a $0 lease bonus. And the reason for that is because every barrel of oil that's produced, that royalty rate, is multiplied by, your proportional share of the unit where that well is producing from, and then also by your royalty rate. So if you settle for a 12.5% lease and a high bonus payment, you're cutting the value of those minerals in half if you ever go to sell them in the future, because the value, just by simple math, 25% is twice 12.5%. And that 25% versus 12% would go into your decimal interest calculation for that well. And your share of the production before any costs, are subtracted if you have post-production costs or anything like that, which is a whole nother concept and discussion. But all of that determines how much you get paid and what the amount is in that royalty check each month. So, again, every dollar of revenue from a well gets divided up amongst all the interest owners, both the mineral owners and the working interest owners. And I go into this in a lot more detail. So this is just sort of a high-level overview, and I go through this concept and talk in detail about the working interest side of things as well in my Mineral Management Basics course. So just a quick highlight there. If you're finding this information interesting and helpful, and you want to learn more about the other types of oil and gas interests, how they all fit together, and then all the important documents you need, and how to perform a title search and locate your property on a map, check my online course out. And you can go to mineralrightspodcast.com/courses to find out more there. But, I think just to wrap up the mineral estate, and then we'll just briefly touch on the leasehold interest, because we did sort of allude to that at the very beginning. And, when somebody inherits these types of properties, often they get a royalty interest that's not part of the mineral estate. And we'll talk about how that can happen. I think that as we wrap this up, Justin, in terms of the royalty payments, let's just sort of talk about 5 real world examples of these different types of ownerships in practice. And that's, I think where we talked about the non-participating royalty interest and that where that fits in.
Yeah, we see these common packages of the bundles. So there are some prevailing things. So there's the full mineral estate, non-producing. So you own all 5 sticks in the mineral estate. Your minerals aren't currently under a lease. Otherwise, you would have leased off one of those sticks, and you own the subsurface right, or just the subsurface right. You have the executive right to negotiate and sign a lease if a company approaches you. and you'd be entitled to that bonus payment and royalties if you lease. And Matt, this is often what we refer to as like non-producing minerals, or you knew that your ancestor owned this property. However, there is no active production happening there. This can typically be the case, though it could be a different type as well. So there's the producing mineral and royalty interest. So you own all 5 sticks. Your minerals are currently under a lease. So you signed one of those sticks over in that lease. And then this is the most common situation. So they're generating the royalty payments. You receive the bonus. You signed that lease, and that lease is held by production or still in the first primary term. Next, you have your undivided mineral interest. You own a fractional share of the mineral estate alongside other co-owners, each of whom has the right to the same pool of minerals under the tract. An example of this would be a grandfather who owns 100% of the minerals under his land. He leaves equal shares to his 2 grandchildren, and each grandchild now owns an undivided 50% interest, not the minerals under 1/2 of the property, but 50% of the minerals under all of the property. And Matt, this gets kind of complex and confusing for folks, but that undivided interest can be tied to a large plat of land, and then you're going to receive 50% of any of that land. And then it's common nowadays, Matt, these become fractionated over generations. And you mentioned this a bit at the beginning of the show with undivided mineral interest, and that it allows each heir to be able to do what they choose with their undivided share. And then we've also mentioned the last one here, which is non-participating royalty interest, which it's a royalty interest that's been carved out of the mineral estate and holds only one of the sticks, which is the right to receive royalties. That allows you to receive those royalty payments, but you don't have the right to lease the minerals. You don't have a right to receive the bonus payments, and you really don't impact the signing of the lease, the terms of that lease at all, because you don't have the executive right. They simply receive their fractional share of royalties if and when a well produces. And Matt, there's another concept with NPRI, which is fixed versus floating. This is where NPRIs really can get tricky for people. It has a real financial consequences. If an NPRI is floating, it's calculated based on the royalty provided for in an oil and gas lease. It floats up and down with the lease royalty. If it's fixed, then the fraction is constant regardless of what the lease royalty is, which I would say is probably the better situation for most royalty owners, though both are very common.
Yeah, and it can be a big difference. And there's been lots of litigation, particularly in West Texas, where this can mean the difference between, millions of dollars when we're talking about a floating royalty that is dependent on the royalty rate that's negotiated with the oil and gas lease. So if you have a 1/8 floating royalty, it's 1/8 times whatever the royalty is, right? Versus if it's a 1/8 NPRI, that's a fixed 1/8. Well, that's 1/8 of whatever the proportional share of the minerals that person owned when they conveyed that NPRI. So it can be a very different fraction when we're talking about those 2 different scenarios. And we actually did a deep dive episode on that whole concept in episode 263 on the difference between fixed and floating NPRIs. So if you have an NPRI, it's a really good idea to listen to that episode to understand which of those buckets you might fall into. One last comment before we talk about the leasehold interest is the concept of an undivided mineral interest applies to both the non-producing as well as producing minerals. So, if you have minerals that are producing or non-producing, typically it doesn't really matter. It's just a more of a status type of a thing, whereas the undivided mineral interest is more of the ownership side of things. So just to clear that up as well. So before we wrap up here, a couple of highlights and important things to know is when you sign an oil and gas lease, you create a whole new set of interests separate from your mineral rights. And these are called leasehold interests or working interests. And understanding them, I think, is important because it helps you understand your role in that well when it gets drilled. Because like we mentioned earlier, all of the interests in a well have to equal 100%. So that division order analyst, when they calculate your division of interest, they have a pay deck, and each well, all of that has to add up to 100%. And that's, logically it makes sense, right? So you have all of the mineral owners together that own their portion of the pie, and then the operator and all the other lessees from those oil and gas leases. And that includes non-operated working interest partners. So if you have a landman that leased your minerals, but they weren't working for an oil company, they were just out there buying leases to have the opportunity to participate in the drilling of a well to get their non-operated working interest. And when I say participate, I mean financially. So that means to pay their proportional share of the cost of drilling and completing that well. They would get what's called a non-operated working interest, and then they get their share of the revenue, and then they pay their share of the cost. And that's the operating cost, and again, the drilling and completions cost, which as mineral owners, which is very important to understand, we don't have to worry about that. We have potentially some post-production costs that may get subtracted for processing gas and for handling the gas. But typically, the only deductions that we get, certainly on the oil side, are severance and ad valorem taxes. So that's like production taxes and any property taxes. And so what that means is basically you don't have to pay for that workover of the well. If the well goes down because the pump jack stopped pumping because the sucker rod broke downhole and they have to fish it out and repair it and stuff, well, you don't have to pay the cost, your proportional share of the cost of that work. Somebody does, and that's the working interest. And that comes from the leases and all collectively, all of the oil and gas leases underneath those wells that are drilled share in those costs of the operating of those wells. So that's an important concept as well. And it's really important to understand that all of this has to equal 100%. And you have, again, 3 types of leasehold interest: the operated working interest, which is the operator, and that's usually the company that drills and operates the well. And they're responsible for the day-to-day work, and the pumpers go out to the lease and they check on things and they all work for that company, or they are contracted through that company. On non-operated working interest, again, these are the investors in the well that don't go out there and actually do the work, but they pay for a portion of the work that happens in the field. And then finally, the last piece is there's a royalty interest that is carved out of the working interest, and that is called an overriding royalty interest. And these, I would say, are common. Certainly with landmen that work on projects, they may get an override in terms of the company outlines, here's the lease NRI that we need, and anything between what you can lease that for and our minimum lease NRI you can keep as an override. And so that's sometimes done. And certainly in the past you'll see, and I've worked with a lot of families that have inherited these types of interests from a relative that worked in the industry. Whether they were a geologist, a landman, engineer, and I know you've faced that situation as well with your great uncle, and that was his business. And so, and you do a deal, you maybe sell a lease, you might try to keep an override. And the thing that's really important to understand about overriding royalty interests is that the override will expire when the lease expires. So it is a temporary royalty, whereas an NPRI typically and a mineral estate, and again, there's nuances there because there's states with dormant mineral statutes, but in general, minerals are perpetual in nature. It's real property you can convey and inherit, and even if you didn't know about it, it's sitting out there. It doesn't expire. It's going to still be there for you to claim. Again, unless you're in a state where there's dormant mineral statutes. But the override as an alternative will expire when the lease expires. And we have more information in episode 43 where we did a deep dive on overriding royalty interest. And so you can learn more there. But that's really the full picture. You have the working interest and you have the mineral interest. And together, they have to equal 100% for each well that's drilled.
And Matt, as mineral owners get into this, you may not really realize what type of ownership it is that you really have. But it's worth asking the questions to your counsel, to your experts of what type of ownership this is, so that you can understand what exactly is on the table for you to manage your minerals. This can be a really confusing thing for people, Matt, just because it is the foundation which everything is built upon. And like working interest, for instance, if you've never encountered this, it could be pretty confusing. So hopefully that helps to kind of shed some light on it for folks. But as you mentioned, Matt, this isn't the full picture. This is so specific to the ownership, so specific to your chain of title. If this is something you're looking at for your property, you really need to start with something like Matt's Mineral Management Basics course to go through it and understand the full picture so that you can navigate your own properties.
Yeah, and the way that starts, partially you can get an idea of what type of an interest is by looking at your revenue statement, your check stub for your royalty check. It'll have a indication on there of what type of interest it is. It'll be an RI or royalty interest. It'll be an override or it'll be a working interest. And so you can look and see, or an NPRI, and it'll show you on the check oftentimes. And you can ask the division order analyst for more information, perhaps get a copy of the redacted title opinion that describes exactly what you own. Sometimes they'll be willing to share that. Sometimes they won't. The real picture is the way to get a true picture of what you own is by performing a title search to obtain copies of those deeds in the chain of title where you understand where something might have been carved out, like an NPRI that could have been granted by your ancestor. That means that there's someone else that owns part of that royalty interest. And really the only way to figure out exactly what you own is by performing a title search. And in my course, I show you how to do that as well. So you can start to get copies of your deeds and leases if you don't have them already. But that's a good place to go. And another great place is the National Association of Royalty Owners. It's really the best place to go for long-term in-person networking, and we have conventions and other things like that. It's a great organization that advocates for mineral owners' rights. And you can use the coupon code MRPodcast to get $25 off your first year of membership at join-narrow.org, and we'll link to that in the show notes as well. Justin and I are both members and have been members for several years and volunteer on the board in various capacities as well. So again, we'll link to all the references we mentioned today in the show notes. And really, I think the key thing to remember is the mineral estate is comprised of multiple rights. There are 5 rights you need to worry about with the minerals. That's the right to drill, the right to lease, the right to receive a bonus payment, the right to receive delay rental payments, and the right to receive royalties. And what exactly that looks like for you as an owner of these interests will be dictated by exactly which of those rights you own, or if you own all 5 of them, and what you can and can't do with that property. So hopefully this helps in kind of shedding some light on the mineral estate and how that works with all of this, because I think this is a really important concept. As mineral owners, we should all have a working knowledge of these different rights, because it'll determine, what we can and can't negotiate in leasing, or, things like that. So it's a really important concept.
Well, Matt, I think that's a pretty good overview. And again, we'd urge folks to learn more, look at your properties specifically so you can understand what sticks in the bundle you own, which determines so much.
Absolutely. All right. Well, thanks again for listening. And thanks, Justin.
Thanks, Matt.
Thanks so much for listening to the Mineral Rights Podcast with your host, Matt Sands. Don't forget to subscribe and share at mineralrightspodcast.com. The Mineral Rights Podcast should not be construed as investment, legal, or tax advice. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy.